Okay, so like I said, I'm Tim Chance. I'm a Tangled Title Attorney at MVLS. Oh, geez. Okay, I didn't realize that chat was disabled. Okay, thanks for that. So I am a Tangled Title Attorney at MVLS, and I help oversee our My Home, My Deed program, which is geared towards community stabilization through estate administration. So as part of that program, we've encountered many barriers to homeownership and wealth building in Maryland's communities of color specifically. And in these communities of color, we've noticed an absolute, an absolute issue with tangled titles. So these are situations where our clients are living in the family home, but that home is still titled in the deceased relative's name, and the path to clearing title is done through the probate process. So estate administration is inherently a costly, time-consuming, and confusing process. So it's absolutely critical that MVLS volunteers are well informed about this process so that we can effectively advocate for our clients and surmount the barriers that are inherent. So before actually diving in, if you have any questions, please put them in the Q&A section, and I will address those at the end of the slides. And with that, we'll get started. So before diving in substantively about some estate administration issues, I just want to provide a quick overview of MVLS and the work that we do. So MVLS connects Marylanders facing economic hardships with volunteer attorneys and community partners to deliver free civil legal assistance, because we believe ultimately that everyone should have justice, not just those who can afford it. So our volunteers provide full representation when brief advice is insufficient to resolve a dispute. And we use pro bono representation to help close the justice gap, but at the same time, we're seeking to close the racial wealth gap. Next slide. There we go. So in the US, our legal aid system currently meets just 20% of the need for civil legal assistance. That means the overwhelming majority of people who cannot afford an attorney are at a severe disadvantage in court. At MVLS, we leverage the power of pro bono to help close the justice gap. Like I said, our ultimate goal is that all Marylanders have access to the civil legal resources and representation that they need to protect themselves, their families, and their homes. Make sure this has been answered. So in MVLS, we offer representation in 6 areas of civil law. So estate planning and administration, which is the focus of today's webinar; housing, such as foreclosure, so mortgage foreclosure and tax sale foreclosure; family law issues such as divorce and custody; criminal record expungement; consumer issues such as bankruptcy; and then income tax controversies. Okay. Sorry, it's another technical issue. Okay, so at MVLS, we're trying to reduce the barriers created by structural racism. So many of the barriers that our clients face are the result of long-standing systems of structural racism in our community. So we're talking about redlining, blockbusting, restrictive covenants, unequal access to GI Bill. So issues that we see today, such as tax sale foreclosure and unemployment criminal records, are directly related to these housing and criminal justice policies that have discriminated against people of color. So obviously individuals have been impacted, but so too have entire communities. So at the My Home, My Deed, My Legacy program, that's just one example of an MVLS initiative aimed at community stabilization. And through our work, we strive to create a more equitable justice system. So I just want to provide a little background on MVLS's My Home, My Deed, My Legacy program as well. So as part of our work addressing and representing homeowners during the foreclosure crisis of 2008, we identified a significant barrier to homeownership in tangled titles on many of the properties in Baltimore and in the entire state of Maryland. These barriers were leading directly to the extraction of wealth in Black communities and widening the wealth gap. So we realized that we needed a two-pronged approach to addressing this issue. So we needed proactive measures, such as estate planning on the front end, so we're making sure folks have their wills, the powers of attorneys, the advanced medical directives, and tools to avoid probate where possible. But we also want to help those folks who already found themselves in tangled title situations. So that's where the estate administration component of the program comes into place. So with that, I think I'll get started on like the list of 10 of the, I would say 10 of the more common issues that we've been seeing in our estate administration cases in, like I said, Baltimore City specifically, but in other counties as well. So the first step that presents an issue for many of our clients is determining the value of the estate in order to file the correct petition for administration. So the value of the property that is titled solely in the name of the decedent is what we're going to be looking at that first step. So that includes any real property that the decedent owns solely or as a tenant in common. So for real property, to determine the value, the registers across the state accept the assessed value from SDAT, from the State Department of Assessments and Taxation. But the assessment needs to be from the year that the decedent died. So it may require contacting the State Department of Assessments and Taxation, or SDAT short, for a historical assessment. There are some specific requirements in Baltimore City for determining the date of death value for real property. So if the date of death is before January 1st, 1998, there will need to be a formal appraisal. But if the date is after January 1st, 1998, then the historical assessment from SDAT is acceptable. And you can just call them to get that historical assessment. For personal property, such as vehicles, we can use the Kelly Blue Book value from their website from the year of the date of death of the decedent. That's just for cars and SUVs and vans. If the decedent owned a boat, a motorcycle, or a trailer, then a formal appraisal by a certified appraiser is going to be required. So there are some assets that require a letter stating the date of death value. So if the decedent had an insurance policy that named the estate as the beneficiary, the value of the policy from the insurance company must be provided in that letter. If the decedent owned any stock without a named beneficiary, then they'll need the value of that stock as well. But you can get that from the Wall Street Journal. That's acceptable to get the valuation of those stocks. In any event that the Baltimore City Police Department has any of the decedent's tangible personal property and evidence, you can also need a report from the city's police evidence control section. So after determining the value of the assets, then you're going to deduct the values of any liens secured by any real property or vehicles, such as with a mortgage, obviously, or a loan or a vehicle. So after deducting all secured liens, then you'll have the value of the estate. So if the value is less than $50,000 or $100,000 if the surviving spouse is the sole legatee, then that estate is a small estate. If the value is more than $50,000 or $100,000 again, if the surviving spouse is the sole legatee, then the estate is a regular estate. So I think I just covered this. So opening an estate requires several forms. So if any forms are missing, that should. Sorry, I'm oh, that should say, sorry, that should say number 2, missing forms. So disregard that. We haven't skipped this, an issue yet. So Opening the estate requires 7 forms. If any of those forms are missing, the registrar may send materials back to the client and the attorney, which requires both of them to resubmit their materials until all necessary documents and forms are included. And like I said, the estate administration process is inherently time intensive. So having those missing forms and documents at the first steps just adds unnecessary weeks, possibly months to a grueling process. Also, it adds cost and just extra logistical issues for both you and the client. That's more mailings, that's additional trips to the mail, to the register. That's extra expenses for the client, such as transportation, childcare, time off of work. So having these forms in order is critical. And knowing whether the estate is a small or regular estate matters because there are additional filing requirements for a regular estate. So for small estates, there is a pretty thorough list of forms that need to be filed. And that list is only longer for regular estates. So for small estates, firstly, you're gonna need to file a petition to administer the small estate, a Schedule B, which reports all assets and debts of the decedent, a list of all interested persons. So that's all of the heirs of the decedent. So that's the surviving spouse, children, and any other person who would inherit if the decedent died intestate. And if the decedent died with a will, that's anyone, so that's the personal representative named in the will and all legatees named in that will. So they'll also need to consent to appointment of personal representative. So this form is only applicable when the petitioner is someone other than the PR name, the personal representative named in the will, or there is someone that has greater standing to serve as PR, as personal representative. So if that is the case, if either one of those is the case, then that person with the greater standing to serve as personal representative or the named personal representative in the will need to consent to the petitioner being appointed as personal representative. There also needs to be an acceptance and consent signed by the petitioner stating that they will follow all responsibilities and accept all duties of being appointed as personal representative. There needs to be a notice of appointment to creditors and to unknown heirs. And if the personal representative is out of state, there needs to be an appointment of a resident agent in Maryland as well. And lastly, for the small estate, there needs to be an information report which reports all the assets that the decedent held in a less than absolute. So sorry, I lost myself here. So there needs to be an information report which includes all the assets which the decedent held in a less than absolute or whole interest at the time of death, or assets that had previously would have passed through a beneficiary. So basically it's assets that would have passed outside of probate. So these include like jointly held assets that are held with the right to survivorship, like a life estate deed where the decedent is the life estate tenant, and any payable at death designations for any bank accounts, any transfer on death designations for vehicles to the NBA, and any real property that's located outside of the state of Maryland that's in the decedent's name only or as a tenant in common. So for a regular estate, all of those same forms need to be filed, but there are some additional filings which include, towards the bottom of that list there, the inventory, which must be filed within 3 months after the appointment of the personal representative. And that inventory needs to include property owned solely by the decedent and the decedent's interest in any tenants in common property. And each item in the inventory needs to be listed in a reasonably descriptive detail. And it needs to indicate the gross market value, the gross fair market value at the time of death, and the type and amount of any mortgage on that property, or any encumbrance on the property. And for like real property, there needs to be a description that's sufficient to identify the property. There also needs to be accounts filed within 9 months after the appointment of the personal representative. So the accounts need to include the beginning value of the estate. So that's reported in inventory, any principal receipts, and then any change in assets from basically after the death of the decedent. Any income that's been accrued by the estate as well, any disbursements, any distribution in taxes, and then the balance retained for that final account. There also needs to be, for our clients, for MVLS clients, a request for the waiver of fees. So all of these forms, with the exception of the accounts, can be found at the Maryland officer, at every county's office of the Register of Wills, or on their website. And there's a link here. And I can also just share that with the attendees. I'll put that in the chat, maybe towards the end. But all of those are available at the website. For the account, there is no form that's readily accessible, but MVLS has a template accounts that we provide to our volunteers. So next one. Sorry. There we go. Okay. So even if you have all the forms are included in your initial filing, the register may not open the estate if there is some information that's missing. So, for example, in the list of interested persons, that form must include the name of the personal representative in addition to the names of any interested parties. So again, this creates just the same burdens as missing forms for our clients when the missing information cannot be written in right away, especially when we need a wet signature from the client. So some of the biggest documents that are absolutely crucial when filing, and really no way to get around those, is the original will. So if there is a will, the decedent has a will, it absolutely must be the original. It cannot be a copy. If the client only has a copy, it's essentially as if the decedent died intestate. And having that original will is critical and crucial when there are multiple interested parties, because that will hopefully promotes unity and accord amongst the family. Without that, there's the potential for strife and potentially a contested probate, which unfortunately we cannot assist with. So if there is a will, it is absolutely crucial that the client locate that will. They'll also need the death certificate for the decedent, the funeral bill, the title to any of the decedent's vehicles that do not have a transfer on death designation, any bank statement for any bank account without a transfer on death designation, and then a copy of the deed for any real property that has not passed outside of probate. So any property that's owned by the decedent solely or as a tenant in common. What's up there? So in addition to those statutory requirements, there are a few specific requirements at some local registers, specifically Baltimore City and Prince George's County. So in Baltimore City, a photo ID is required for the person filing for probate. So generally the petitioner for a personal representative needs to also have their photo ID at the time of submitting the petition for the administration of the estate. And like I previously mentioned, if there is any tangible personal property that is being held in the custody of the Baltimore City Police Department, then you'll need the report from the evidence control section. In Prince George's County, if there is tangible personal property and there is no formal appraisal, the register requires a petition to accept the value of that value, accept the value of that personal property in order to bring that property into the estate. So there is no form petition for this either, but we do have a template that we share with our volunteers. But the best practice moving forward is to call ahead just to confirm the requirements at each stage of the process so that there are no surprises or delays in the process. An additional document that MVLS volunteers should include in their filings for all counties, so not just Baltimore City and PG, but across the state, is the MVLS placement letter. So pursuant to Maryland Estates and Trust 2-206, which went into effect October 1, 2019, so a few years ago, the Register of Wills became required to waive estate fees for clients facing economic hardships. So that law went into effect on October 1, 2020. So it's been in effect for about 2 years now. And the law basically required registers to waive the estate fees when the real property of the decedent subject to the administration of the estate is going to be transferred to an heir of the decedent who resides on the property. So that applies to many MVLS clients, or the property is encumbered by a lien and subject to tax sale, and the estate is unable to pay the fees by reason of poverty. So there's two definitions of poverty in the statute, but the one I'm going to focus on is the second definition, which establishes that if the personal representative is being represented by an attorney retained through the Maryland Legal Services Corporation, they meet that definition. So all MVLS estate clients meet those requirements for the waiver, and we've since reached out. So since the implementation of this law, we reached out to the registers across the state, so to every registrar's office across the state, just to alert them to this change, and just to remind them that we can work in unison to ensure that we can have the fees waived for our clients, which are entitled to it under the law, which is all of our clients. So what we now do is we advise all of our clients to submit a copy of their placement letter with the probate fee waiver form. And this letter serves as evidence that the client is being represented by a Maryland Legal Services Corporation funded program, and thus has been screened for income limitations and has met the definition for poverty as outlined in the statute. And this placement letter has been widely accepted by registers across the state. There were some slight hiccups with Baltimore City earlier in this process, but as of October 2022, they're now being accepted by the Baltimore City office as well. And touching on the waiver of fees, with the passing of House Bill 187 in the last legislative session, as of October 1 of this year, October 1, 2022, there are no fees due on small estates. So those are the states, like I said, that are worth $50,000 or less. But please definitely continue to submit the waiver and the placement letter for regular estates. So according to the statute, there are some documents and forms that do not need to be filed at the outset when opening an estate. But recently we've noticed some registers requiring all documents up front, even if they are not immediately necessarily right at the filing. So just as with confirming any specific requirements for local registers, just confirm with the registers directly and try to obtain all documents and forms that can be filled out in advance before going to the register, just to expedite this process and to make it as seamless as possible. So in Baltimore City, although a complete and thoroughly completed list of interested parties can be filed up to 20 days after the appointment of a personal representative, Baltimore City requires this information up front, so at the time of filing. There's also an additional requirement that the $113 that is going to be paid to the Daily Record for publication in the Daily Record is due at the time of filing. So the city is now requiring these up front, although historically they have not been needed to open the estate. They've been needed in the process, but not at the onset. So this is something that we've been noticing. So to, like I said, avoid any delays or any documents being sent back, it's best practice to try to get those, to have those ready at the time of filing. When trying to get that complete and full list of interested parties, well, a best practice I found for our clients is having them complete a family tree from the decedent, just so there's a visual reference of all interested parties, all potential interested parties, so you know who needs to be included in that list and who needs to be reached out to eventually. So just having that family tree has been very helpful to me and my clients personally. So kind of building off of that issue, what we've seen in estates with properties that have severely tangled titles. So these properties whose named owner has passed away decades ago, and their children have, some of their children have since passed away, requiring the opening of multiple estates to disentangle the title. Locating all of these heirs, in Baltimore, people branch out, so we're not just talking about heirs in Baltimore, but across the state and across the country. Locating all these heirs is a roadblock that can cause a significant delay in the administration of the estate. But in order to ultimately proceed, like locating these heirs is paramount. So there are like a few methods that we've tried to come up with to locate these heirs in a somewhat cost-effective manner. The first is obviously just having the client talk to other relatives. Sometimes there are gaps in information among certain branches of the family that may be answered by other cousins or other aunts, uncles. It's also just worthwhile to check out the deed itself. That may have some information, a name that can be a clue to locating other heirs. Likewise, you can check on the State Department of Assessments and Taxation to try to find any record owners who may be a starting point, a jump point for locating other heirs. A kind of innovative approach is also just using Maryland Judiciary Case Search to try to, if you have a potential name, try to get some contact information for that heir. For folks that have passed away, and the client may not know when they passed away or where they were at the time of their death, obituaries are very helpful, not only just from like the physical obituaries from relatives, but searching online has been helpful, because that gives us not only a date and place of that interested party's death, but also it includes generally a list of surviving family members, so further points of contact that we can reach out to. And then in the event that like these more innovative and cost-effective avenues are fruitless, then it may require hiring a private search firm or searching like the Social Security Death Index. So beyond just the fees for opening an estate and the fees for publishing, the appointment of the personal representative in the Daily Record, there are several secondary costs that arise and remain as barriers for many of our clients. And one of those major barriers is probate bonds. So a bond of personal representative is required to guarantee that the personal representative will lawfully fulfill their duties as personal representative of the estate. But this bond may be waived by the will if there is one. And if there is no will, then by written waiver of all interested parties. Fortunately, even if the bond is waived through the will or by waiver, a nominal bond may still be required, and that is universal across all registers across the state. And in order to apply for a bond, a credit check is required for most companies. And if that applicant, if the petitioner is deemed to not be creditworthy, it's going to prevent them from serving as personal representative, despite any express wishes in the will of the decedent or the express wishes of other family members. So that just presents another potential barrier for our clients that just could clog up the process. So we have found it to be helpful to reach out directly to the register, the local register in the county where the estate is filed, to get recommendations on companies that can provide bond. There are a certain number of companies, specifically here in Baltimore, that do not do credit checks for nominal bonds. So that is one avenue that we found to try to not get around this, but to address this issue. Another issue that we've seen somewhat recently with the bond requirement and just the bond itself is, once the bond is executed, it's generally sent directly from the issuer of the bond directly to the register of wills. But we've seen that sometimes that bond can be lost. And that obviously presents an issue, because if it's lost in that process, this is another cost that has to be incurred by the client, and it may have been extremely difficult to gather the money for that first bond. So it's good to be cognizant of this, and it's good to stay on top of the register of wills. We have in the past hounded them to find it, and they found it, but I just wanted to put that on folks' radar, that it's not always as seamless as it can be. So the next issue I want to talk about is the appointment and duties of the personal representative. So once we've taken care of all the other issues, once we got the forms filed correctly, once we got the bond taken care of, the client is going to be appointed as personal representative. And upon that appointment, they're going to be a fiduciary under a general duty to settle and distribute the estate pursuant to the will, if there is one, or in compliance with the laws of intestacy, and as quickly as possible. They also going to need to consider the interest of all interested persons and creditors fairly and equitably. And a major thing that we've seen be an issue for our clients is, once the estate's open, the register is going to give out a list of deadlines and what needs to be done by those deadlines. And it's absolutely imperative that the personal representative and the attorney be aware of these deadlines and meet these deadlines. So generally, these estate administration cases are purely administrative. They're just filings. But we have seen more and more hearings to remove clients or other folks as personal representatives due to a failure to meet their duties as personal representative. So it is, like I said, absolutely imperative that you stay on top of those deadlines. And if you're having trouble with an accounting or getting an appraisal or making a distribution, you can always request an extension, but you just need to do that in a timely manner to ensure that you're not and the client's not derelict in their duties. Another major issue that has been, I think, pretty evident in a lot of our probate cases, beyond just general creditors, but there is special provisions for the state of Maryland as a creditor. So they have more time to file a claim than a general creditor would. So generally, a creditor has 6 months from the date of death of the decedent to file a claim. With the state of Maryland, they have 6 months from the appointment of personal representative to file a claim. So they have a much longer time to file the claim. And generally, the Maryland Department of Health is pretty aggressive in trying to recover any costs incurred for Medicaid if the decedent had Medicaid or ended up in a nursing home facility. So generally, they will try to place a lien on the property and recover their costs that way by enforcing that lien. There are certain exceptions to the Maryland Department of Health placing a lien on the property. So a lien can be placed on the home if a surviving spouse, a child under the age of 21, or a blind or disabled child live there. However, if none of those requirements are met, then they can place the lien. If those exceptions aren't met, then you can petition the Maryland Department of Health to waive the claim for undue hardship. So in order to have a viable argument for this waiver to be granted, you need to show that the enforcement of the claim would result in the removal of a dependent that has lived on the property at the time of the benefit recipient's death, has lived there continuously for 2 years before the decedent's death, and cannot find another place to live. So unfortunately, this is a pretty high bar to meet. And if the client is not able to meet these elements, the state of Maryland could place a non-interest bearing mortgage on the property, allowing the client to stay in the home, but not completely waiving their claim to the home. So there's no form for seeking this waiver, but we do have, just like with the other documents I mentioned, we have a sample that we can share with our volunteers, and I've actually included that in this training. So this is just what it looks like. So we have that available as a resource for folks that may have encountered or will encounter this issue. And the last issue that I want to talk about today is just reopening closed estates. So like I said, estate administration cases in the process is just inherently time intensive. Regular estates need to be open for at least 9 months. So we've seen an influx of clients that have already opened the estate prior to even coming to MVLS. So they opened the estate pro se, but in the administration of the estate, they were unable to distribute the property due to unpaid liens on the property or other issues, and the estate has then been closed without the distribution of that property. So in a situation like this, the client and the attorney would need to petition the court to reopen the estate for the specific purposes of recording a new deed. And just as with the other petitions I mentioned and the other forms I mentioned, there's no form for this, but we do have a template that has been fairly successful in the past. And that concludes the substance of the presentation today. Just wanted to plug our social media, so feel free to follow us on Facebook, LinkedIn, Twitter, visit our website. Like I said, I'll be taking questions pretty much now, just through, I guess, the Q&A. I'll try to see if I can unlock the chat, but Q&A should be available right now. But if anyone has any questions that they don't think of right now, if they want to reach out to me offline or anytime in the future, feel free to reach out to me at my email address there. And I'll try to put that in the chat too, so you can just copy that. Okay, so the amount of the nominal bond is determined generally by the valuation of the estate. So generally, we're seeing some real property in the estate, and the amount I've seen time and time again is $100. So it's dependent upon the value of the estate and the assets within the estate, but I've seen 100. I've yet to see it be more than $100. So $100, I think, is a good baseline for how much it will be. So sorry, I should have read that question out. So the question was, how is the amount of the nominal bond determined? So we have another question that states, is there no PR bond for a small estate, even if there is no will excusing it? So even if there is no will, like I said, the other interested parties can sign a written waiver to the bond, to the personal representative bond. But even in that event, there still will be the nominal bond of $100. And I know there's been like a legislative push to remove that bond requirement where it's waived either through the will or through the other interested parties. But as of yet, that has been unsuccessful, unfortunately. Let's chat. Okay. All right. So sorry about the delay, but I think the chat should be open now. But there's another question. So with the death of a parent, are predeceased children still listed as interested persons? So if the children predeceased the parent, then it would just go to the survive. If there's no will, it would just go to the surviving children. One thing I can say, just in regards to like having this available, I can share the slides with folks if folks are interested in that. I have everyone's email, I can email it out to folks. Yes, so the publication fee for the daily record is $113, and that's payable by money order. I would stick to money order. We reached out to the Register of Wills and Daily Record, but they were unable to provide like a concrete answer as to whether personal checks were acceptable. So I would err on the side of money order. Yeah, so the creditors still have 6 months to file a claim, even in a small estate. Yes, so 6 months from the date of death, a general credit 6 months from the date of death for small and regular estates. If the PR provides notice to any creditors, they then have 2 months from the date of notice. So there's a way to shorten it if you provide notice to the creditors of the appointment of a PR in the estate. That's a good question. So the question is a photocopy of the personal representative's ID acceptable if the estate is open by mail? Honestly don't know if I'm being honest. Generally, like I just go down there because they're around the corner, but I can reach out to the Register of Wills and share this answer. I'll just email it to everyone because I think it's an anonymous question, but I'll try to get a firm answer on that. Right. So I'm not seeing any more questions. So if there are no further questions, no worries. Okay. No worries. No, I mean, no, I'm glad that folks are engaged. Okay. So there are no further questions. I just want to thank everyone for attending today. Like I said, I'll send out the slides to all the attendees, and I'll try to get a firm answer regarding whether or not like a photo copy of the ID is acceptable for mail-in petitions. But thank you all. Take care. Enjoy the rest of your day.